All rise. The Honorables, the presiding judge and judges of the Court of Appeals of the state of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good morning. Welcome to the North Carolina Court of Appeals. We have one case for argument this morning before this panel, and that is number 2729, State v. Marion. I'm Judge Richard Dietz, and joining me on the panel today are Judge Lucy Inman and Judge April Wood. We've confirmed the parties are ready to proceed, so we'll hear from the appellant.
Good morning, and may it please the court. I am Lauren Miller with North Carolina Prisoner Legal Services, representing Ms. Tiffany Marion. May I please reserve 5 minutes for rebuttal. The only plausible interpretation of all the evidence in this case viewed cumulatively is that Tiffany Marion was prosecuted more severely in Swain County than her two white co-defendants because she was black. Dean Mangold was, by any view of the evidence, more responsible than Ms. Marion for the events that took place. He was essentially the inside guy. He knew the victims, had worked for one of them, and had stayed at that home. He directed the principals how to get up there. He was armed that night. He walked up to the home. After hearing shooting, he fled, and he did nothing to help his friends who were shot in the home. When he initially met with law enforcement, he lied to them. He denied planning, he denied going up to the house, and he denied having a gun on him that night. When he agreed to meet with law enforcement again, he skipped town and went to New Jersey. He provided no cooperation to the state, and he was not required to testify against anyone. And yet he received a plea to 22 years, 9 months, and he's eligible for release when he is 43 years old. Mark Goolsby, the other white co-defendant, was similarly situated also to Ms. Marion. Like Ms. Marion, he was not involved whatsoever with the planning. He remained at the van. He was unarmed. When his friend Mangold took off, he took off with him. He likewise lied to law enforcement when he first met with them. He skipped town and went to New Jersey, and he was arrested there with the firearm that Mangold had on him that night that they had previously told law enforcement they had thrown into a field. 7 months after the incident, only when facing charges, both for this murder and the gun charge in New Jersey, did he then implicate his friend Mangold as having planned this event, and did he agree to help the state? He testified at Ms. Marion's trial without any plea offer, facing first-degree murder charges. About 3 weeks after Ms. Marion's trial, he entered a plea to a total minimum sentence of 7 years. He was released in 2016. Ms. Marion, like Mr. Goolsby, was not involved whatsoever with the planning of the event in this case. She was high, she was unarmed, she remained at the van through the entirety. She rode in the truck back to Georgia with Miles, who was the principal, and then she was arrested in her friend Jada's apartment, where some of the stolen property was located. When she initially spoke to law enforcement, she also was not truthful. She denied that she had gone with the group to the home. But on the way up to North Carolina, she told the officers who transported her many more details and all that she had learned in the meantime. She was 25 years old at the time of this offense, with only a conviction from high school for shoplifting. Despite her trial counsel's repeated efforts, including going to the sheriff to try to convince the state to offer her a plea, the prosecutors in this case refused to make any plea offer to Ms. Marion, instead trying her for first-degree murder based on felony murder and acting in concert. She was convicted and sentenced to life without parole, the exact same sentence as the two principals, Miles and Johnson. At the evidentiary hearing on the motion for appropriate relief, when the state was asked to explain this disparate treatment, they gave reasons that were demonstrably false or pretextual. For the first time at the evidentiary hearing, they claimed that Ms. Marion had gone up to the house that night. This was never the state's theory of the case. They did not advance this formally at her trial, and they did not advance it informally even to her counsel. It was also flatly contradicted by all of the record evidence. The state made 4 separate factual bases to the court, and in every one of those factual bases, both before and after Ms. Marion's trial, the state maintained that Ms. Marion remained at the van. Every single one of the witnesses who were available, including Mr. Goolsby, who testified at Ms. Marion's trial, as well as all of the witness statements from Mangold, from Jada McCutcheon, and from victim Waldrop, all had Ms. Marion remaining at the van and not going up to the house. There was not a single piece of evidence that corroborated the state's position that Ms. Marion had gone up to the home. Additionally, when trial counsel at the evidentiary hearing was asked to review Ms. Welch's factual basis at Mangold's plea and asked whether Ms. Welch had represented that Ms. Marion went up to the home, counsel responded, "No, that was Ms. Welch's recitation. She never would have said anything like that to the court," which clearly demonstrates that the prosecution had never, at any point leading up to Ms. Marion's trial, suggested that Ms. Marion had in fact gone up to that home. When the prosecutor's reasons are clearly contradicted by the evidence and also shift over time, it's evidence of pretext. The state also offered at the evidentiary hearing that Ms. Marion was not offered a plea because she was too young, and if she had been offered a plea, she would have just been able to discharge that sentence and to reoffend. When the reason that the state gives is equally applicable to the white co-defendants, it is also evidence of pretext. Here, Dean Mangold, the more responsible white co-defendant, was 20 years old. He did nothing to cooperate, and yet he received a plea offer of 22 years, 9 months, which he accepted. He's eligible for release at 43 years old. Additionally, in terms of there being risk factors or Ms. Marion's likelihood to reoffend, the state had, before offering Mr. Mangold a plea, a psychological evaluation from his attorneys that detailed far more risk factors and problematic information than the state had any reason to believe existed for Ms. Marion. Despite all of those risk factors, despite Mr. Mangold having a higher prior record level than Ms. Marion, he still received a plea offer. The state also gave a patently incredible reason, claiming that Ms. Marion was not entitled or deserving of a plea because she did not withdraw as the white co-defendants Mangold and Goolsby did. Labeling their flight as withdrawal is incredible. Under our law, for a defendant to withdraw, they need to communicate to the other defendants prior to the occurrence of the offense that they no longer desire to be involved. They need to say that they are out. Here, what happened was after the elements were already entirely completed and shots were heard, Mangold and Goolsby fled into the woods, doing nothing to help the victims. That is anything but withdrawal, and for the state to label it as such is evidence of pretext. The state also gave the reason that Ms. Marion was not offered a plea because she was not truthful or did not cooperate with law enforcement. But again, when this is examined carefully, we see that Mangold and Goolsby, likewise, were not truthful when they initially spoke to law enforcement. Both of them denied that there was any planning involved on the part of Mangold. They denied that Mangold went up to the house, and they denied that Mangold was armed that night. Mangold only came clean about having a weapon on him after he was confronted with information by law enforcement that other witnesses said he had a gun on him that night. And Goolsby only provided information after he was arrested in New Jersey with the very gun that they had said was thrown into a field. If Ms. Marion were in fact not offered a plea just because she did not cooperate, then Mangold likewise should not have been offered a plea. As he did not cooperate with law enforcement, he maintained to the very end that he was not involved whatsoever with the planning. And so to the state's contention that Ms. Marion's statement was self-serving, if we look carefully at both of the statements given, well, at all of the statements given by both defendants, Mangold and Goolsby, we see that their statements were self-serving as well. Mangold throughout maintained that he did not take any part in the planning, and that instead, he believed that they were going to either be selling some guns there or they might be trading some drugs, but that it was only after he had guided them to the home and directed them where to park did then the principals essentially flip on him and make it clear that this was a robbery. But all the way to the end, he maintained he had no involvement in the actual planning or desiring to have a robbery take place. So his statement was entirely self-serving and should have also eliminated him from receiving a plea offer if the state's reason were legitimate and were not pretextual. The state also contended
Can I ask a big picture question here? I mean, when I looked at what the prosecutors were trying to explain, it seemed like putting together some of what you've called, like I heard you use the word incredible and things like that, but of course we don't find facts, so we're looking at what the trial court found and then, you know, whether there's evidence to support that. But it seemed like what the prosecutor was saying is these other two, the two defendants who received the plea offers, essentially said, I did not sign up for this at some point during the commission of the crime and left, but your client stayed and then later benefited from the crime in other ways, for example, by going back to, I think, at the stolen truck, returning to Georgia and some other things. So what, you know, can we look at a big picture reason like that, or do we have to do what you're asserting here, which is look individually at each of these assertions and assess whether they're pretext? Are you following what I'm saying? Like, can we look collectively at this and say, what's the big picture reason the prosecutors might have done what they did here?
I think what our equal protection law requires, Your Honor, is that these reasons cannot so much be looked at in an isolated fashion, but the court needs to look to all relevant circumstances and engage in a sensitive inquiry. And if we were to look to, for example, in Foster v. Chapman, that's a case in which they looked at a laundry list of reasons that were given by the prosecutors for why they chose to use peremptory challenges against certain jurors. And what the court did was started to look one by one at each of the reasons that were given. But once the court reached a point of determining there was sufficient, that the reasons were either sufficiently contradicted in the record or that there was evidence of them being pretextual, at that point the court said enough is enough and ended the inquiry. So for one of the jurors, the court had gone through 4 of the 11 reasons that were given by the state, and in the other juror's case, they had gone through 5 of the 8 reasons, and once that many had been determined to be pretextual or inauthentic, at that point the court said we have sufficient evidence of a discriminatory intent. And so with that in mind, I think some of what you had just mentioned, Judge Dietz, both the state saying, well, I guess to the extent that it was, they didn't sign up for this, the evidence was absolutely Mangold signed up for this. This was exactly what, he was the one who knew the victims, he was the one who told the principals that these guys had drugs, they had guns, that essentially they were targets. He made them targets, and then he directed those principals up long and winding roads in Swain County where they never could have found this home otherwise. And according to Goolsby, he was also involved in the planning both at the hotel and then also in the van on the way over there. So any argument that Mangold did not sign up for it doesn't hold weight when actually examined against the record evidence. Now, in terms of withdrawal, or them choosing to leave once they heard gunshots, I had already earlier addressed that withdrawal is not a credible reason, and to characterize it as such when it was in fact flight, I think speaks for itself. Moreover, I think Goolsby was in a distinct position there as he was clinging to his friend Mangold, whereas by all the evidence, Ms. Marion's connection to coming up to North Carolina was her friend Jada McCutcheon, who was still there, who had gone up to the home. And so it's also not reasonable to suggest that a young woman should have run off with 2 men she didn't know into the woods in a place that she did not know, men who were armed, men who were evading prosecution. I think the reason that she stayed that night was she was clinging to the people who would give her an opportunity to get home. And so I think they were in distinct positions there, and it's not credible to say that she should have run off into the woods under those circumstances. And in terms of profiting, to Your Honor's point, or to your question, I think profiting is certainly one reason that was given by the state that initially could be viewed as legitimate. And I've acknowledged throughout, prosecutors can have a wide, myriad number of reasons to decide not to offer a defendant a plea. Where it violates equal protection is when they do not have a legitimate reason for doing so. And so while profiting on its surface might seem to be legitimate, it has to be considered not in isolation, but in the context of all these other reasons that have been given that have been shown to be pretextual and contradicted by the record. And so in light of that, and then also, the state offered profiting as a reason for the first time at the evidentiary hearing. There was no independent evidence to corroborate that reason that was given by the state. There was nothing in any of their emails. It's not as though at any point leading up to the trial, they suggested to Ms. Marion's attorneys, we can't offer her a plea because she profited, we view her differently. They never suggested any of that. And so it reeks of afterthought for them to come up with that distinguishing characteristic of her profiting at the evidentiary hearing. Have I answered your question, Judge?
Thank you.
The state also contended that Ms. Marion was just as guilty as the principals Miles and Johnson, and presumably they meant that under the felony murder rule. But again, if we were to look at that reason more carefully, it applied equally to the white co-defendants. There was in fact more evidence of Mangold's involvement, especially before the offense even took place. And our law has always penalized actions or involvement before the crime more severely than involvement afterwards, as demonstrated by accessories before the fact being punished as principals, while accessories after the fact are punished less harshly. The state also claimed, the lead prosecutor in the case, who was charged with determining whether Ms. Marion should be offered a plea, testified at the evidentiary hearing that Ms. Marion's counsel told him that she would not plead to anything. This was contradicted by every piece of evidence in the record. And clearly the trial court did not believe it, because we had argued in the alternative that trial counsel would have been ineffective for not having pursued a plea offer throughout when Ms. Marion was facing the death penalty, as it was a capital case throughout most of the pretrial time. Trial counsel Jack Stewart testified at the evidentiary hearing that that conversation never happened. He gave much greater testimony as well, talking about why a trial in this case was a measure of last resort, and he thought the risks were immeasurable. He and co-counsel Caleb Decker were doing everything that they could to avoid a trial in this case. And he also spoke to, while he would normally view Swain County as an acceptable place or a positive place to have a trial for a defendant, he said this case was different. The racial tensions here were different. And essentially, I think he referred to himself as, he felt like an alien out of place there and recognized that Ms. Marion was the same. The other prosecutor who testified as well at the evidentiary hearing also contradicted this pretextual reason that she would not plead to anything. And she testified as to how both of Ms. Marion's counsel were constantly doing all they could to try to get a plea offer for her. It was contradicted by Ms. Marion's jail phone call to her mother about 3 weeks before the trial, where she was explaining her discussions with her attorneys and how they were still doing all they could to get a plea for her, and that she should consider a plea possibly to robbery or to accessory after the fact to robbery. It was further contradicted by Ms. Marion's own trial testimony, where she said, I feel like my life is being toyed with here because I'm hearing about all of these other people who are being offered pleas, and she didn't understand why none was ever available to her. I'd like to shift at this point and discuss the standard of review that applies, and specifically Judge Dietz, since you had referred to this court not being in a position to do factual findings. This, as is evident from our briefs, is an area of the law that is unsettled or unchartered in North Carolina. While equal protection law is clearly established, this is a more nuanced claim. It's not a Batson claim. It's not a pure selective prosecution claim. And so this court is not bound necessarily by an existing standard, or there's not ample precedent from which we can clearly say this is definitely the standard that applies. And so what we can do, though, is draw from the most applicable precedent. And in the Memorandum of Additional Authority that I filed earlier this week, I'd pointed to the fact that this court reviews, and our Supreme Court reviews, any constitutional claims de novo. And I also argued in the brief that a de novo standard review is appropriate here because the court is so much involved in having to actually examine the record and is not bound by, there were not relevant factual findings here to which the court is tied that demonstrate any actual evaluation of the appropriate equal protection law. And so a much more applicable, I think the closest analogy that we can draw is to, yes, Judge.
Sorry to interrupt you, just to make sure before I lose that thought. So there you're arguing that the trial court did not consider the evidence before it, didn't make any regarding your equal protection arguments, did not consider the evidence that it should have considered, and that this court should be able to make a fact-based analysis of that evidence that's beyond the scope of the trial court's order?
What I'm arguing, Judge Inman, is that this court is equally equipped to make all the necessary findings as the trial court was. And I'd like to explain why. So for one, while the state has argued that this is the equivalent of Batson, I have argued Batson for purposes of, Batson has given us a roadmap for how we unearth discriminatory purpose. But that's the extent to which we use it here. This is not a pure Batson claim. And the trial court, in a Batson setting, determining whether peremptory challenges are pretextual, is entirely different. Essentially, the court becomes a witness there in having observed all of voir dire, which is extensive, and getting a chance to view that prosecutor over a period of time, as well as all of the jurors over a period of time, and to see how that questioning goes. Distinctly here, I think the trial court is more so in a position, as a trial court is in a claim of vindictive prosecution, which is much more sensitive to all of the record evidence and all of the procedural history as we are in this case. And so that's why I think it's distinct from the role that a trial court is in for a Batson setting.
But so let me return to one of the issues you'd raised to try to work through how this would work. So would you agree that there's some evidence in the record that your client was not interested in a plea? I mean, you've certainly argued that you don't find that evidence credible because of all the counter evidence, but is there some evidence in your view to that came in?
I would say that the only evidence that Ms. Marion was not interested in a plea was Jim Moore testifying that counsel said she would not plead to anything.
And so we have a lot of case law that says when a fact finder is making a finding, even if so, the example we often give is, there were 100 witnesses to some car accident, and 99 said the light was red for this person, but one witness says, I think the light was green. And if the fact finder says, we think the light was green, those 99 people are liars. This one person is telling the truth. We have no choice but to say that there's competent evidence to support it. So that typically is our standard, and there's really no situation I'm aware of where we make credibility assessments at the appellate level. So my question to you is, do you think the trial court, in your view, made those credibility assessments? And if so, how do we, consistent with our precedent, ignore that even if we think you've made compelling arguments that there's stronger credibility on the other side? You following me?
Yes, Judge Deeks, I follow you. I think here, though, even if we were to take that there's this one bit of testimony where it's clearly erroneous, it is in fact an abuse of discretion, and that fact finding should not be honored. So that is how I would say we would get around that, and it's not just 1 versus 99. We have to again look to the circumstances here where you had 3 other officers of the court who were directly refuting that, including the other prosecutor in the case, saying they were working relentlessly for a plea, and trial was a measure of last resort. And so where it is so strongly contradicted, it rises to the level of being clearly erroneous to where there should be no deference given by this court. And so in terms of discussing further why a de novo standard of review is appropriate, this is along the lines of in State v. Shalo, which was another case that I presented in the Memorandum of Additional Authority this week. The trial court there in a vindictive prosecution case has the benefit of having seen what occurred pre-trial, actually at a trial, through an appeal, and then what the prosecution chooses to do at that stage. Likewise here, this was a claim that could only be raised for the first time in post-conviction, where the trial court should have been considering everything that occurred pre-trial, during trial, through the appeal, and now in post-conviction and through the evidentiary hearing. And so I think those are much more closely analogous than to look in a Batson setting where there's significant deference given to the trial court who's observed all of voir dire. It's much more focused on that procedural and record history, and then the trial court, both in the vindictive prosecution claim and in this type of claim, is still charged with having to discern what exactly the intent was of the prosecutor. Why was this prosecution happening? What were the motivations? And so those are equally true. And similarly, in the federal courts, when they've drawn comparisons between selective prosecution and vindictive prosecution in finding that the same standard to be entitled to discovery in selective prosecution cases likewise applies to vindictive prosecution. And so I see that I'm cutting into my time for rebuttal, so I will sit at this time if the court has no further questions.
Okay. Thank you, counsel.
Thank you.
We'll hear from the state.
Good morning, and may it please the court. I'm Mary Carla Babb with the North Carolina Department of Justice here on behalf of the state. Your honors, in this case, these were prosecutors who had demonstrated records of actually fighting discrimination and racial biases and directly confronting and rejecting racially biased behavior. The low defendant did not establish discriminatory intent nor discriminatory purpose to support her equal protection selective prosecution claim, and this court should affirm the trial court's order denying her MAR. I wanted to first address the standard of review. I wanted to agree with defendant that the court should look at the most applicable precedent, which the most applicable precedent here is that which applies to selective prosecution claims and equal protection claims. So defendant is correct. There's no law from our North Carolina Supreme Court or this court about the standard of review. However, for selective prosecution claims, there were three federal circuit courts, the Sixth Circuit, the Eighth Circuit, the Ninth Circuit, cited in either the state's brief or memorandum of additional authority, who hold that because the determination on the merits of selective prosecution claim is essentially a factual inquiry, they would review the fact finder, in that case the federal district court's determination for clear error, which is similar to the assessment or exactly like the assessment of facts in an MAR setting, which is whether they were supported by competent evidence. In a case cited by defendant in her reply brief, U.S. v. Lewis, the First Circuit did something similar. In that case, the defendant argued for a de novo standard review, and the court rejected that, and saying it was such a fact-intensive inquiry that it would reject. Let me back up. That was specifically about whether there was discriminatory effect, whether they were similarly situated individuals. They said that it was so fact-intensive that it belied defendant's assertion that it was a legal determination, and in that case reviewed it for an abuse of discretion, so similar to a clear error determination. And again, the most applicable precedent are equal protection claims. Vindictive prosecution claims are due process claims. So the most applicable precedent on the standard of review would be these selective prosecution claims in the federal court, and also Batson. Batson has the trial court makes a finding of discriminatory intent or lack thereof. There are 4 cases from the U.S. Supreme Court, 2 from our Supreme Court, that hold that the trial court's ruling as to discriminatory intent is under the clearly erroneous standard for the purposes of review, and notes that where there are 2 permissible views of the evidence, the fact finder's choice between the 2 cannot be clearly erroneous. So the applicable standard of review is whether you want to state it as supported by the fact, these are factual findings, discriminatory intent, discriminatory effect, whether you want to say supported by competent evidence or clear error, that is the review for this court. Now, even if the court concludes that they are conclusions of law, they would still be supported by the findings of fact made by the trial court in this case. And the trial court here did consider the relevant factors. I think it's fair to say that this is not the clearest of MAR orders. The language in some of it is a little chunky, for lack of a better term. And under no circumstances does this court do findings of fact. The trial court's order here is sufficient. Again, not the model of clarity that we would like it to be, but it's sufficient for this court to go through it and figure out and see the findings of fact that they support the conclusion of law that there was no equal protection violation here. But in the event the court does not find the findings of fact sufficient, it is not to make credibility findings of itself. The remedy is for it to remand it to the trial court to make those findings of fact sufficient to support its ultimate conclusion. And in this case, the trial court's finding that the defendant failed to prove discriminatory effect, which was labeled as conclusion of law 4, was supported by competent evidence and was not clearly erroneous. And other findings of fact attendant to that were also supported by competent evidence, including that defendant did not prove she was similarly situated, and specifically in finding number 26, she failed to prove that she was discriminated against in relation to her co-defendants. These co-defendants were not similarly situated to the defendant in this case. And Judge Dietz, you hit on what I think is key here, and that is looking at this as a whole. The defendant here had some involvement with this criminal enterprise from beginning to end. That cannot be said about Mr. Mangold and Mr. Goolsby. She had relationships with the principals. Miles indicated to Goolsby that she was his girlfriend. She admitted that at some point along the way that she was intimate with Miles when they were on their trip. Mrs. McCutcheon referred to her as her homegirl, her best friend. So she had this relationship to the people who were the principals here. She decided to go to the site of the crime, and while there's no evidence, the state agrees that she was involved in the planning of the crime. She absolutely knew that this was going to be that a robbery and an armed robbery was going to occur here. Now, she denied that. She denied that to the end, but it's an absolutely implausible denial. She was in the front seat of this van when they were planning the robbery. Miles made it loud and clear when they jumped out of the van to go up to the house about what was going to happen. Ms. McCutcheon said that she heard it. She assumed the defendant heard it. Miles had a shotgun. Johnson had an AR-15. These are not easily concealed. The testimony at trial from the state's witness, Goolsby, was that she was outside the van, and when Miles was loading the shotgun, if she was outside the van, she would have known what was going on, obviously. And she testified that she was in the van, so in the front seat. So she never got out of that seat. So if she was there, Miles was in the driver's seat loading a shotgun. So her protestations that she didn't know what was going on, did not know this was going to be a robbery, are patently incorrect. And she even said, "I'm not going up there," recognizing what was going to happen. And when she found out that they were up there killing people, she stuck with this criminal enterprise. She did not leave. Now, the state is not contending this would be what Goolsby and Mangold did would be an official withdrawal in the law, but they did leave this criminal enterprise, whereas she stuck with it. She even at one point, even knowing that, even being told that they were killing people at that house, she didn't get all the way to the house. She walked up some distance the driveway, told Johnson that, in her words, the white boys had ran away, and asked Jay to hurry up and come on, told her to hurry up. And when she's sitting in the van, she realizes at some point her cohorts are coming down the driveway. She at first tries to start the van, but Jada McCutcheon has to come in and start it because she didn't know how to release the park brake. And a big issue was, unlike her white co-defendants, absolutely profited and benefited from the crimes here, and she assisted in taking them away. She, like all the rest of them, needed a ride back to Georgia. According to Ms. McCutcheon's statement, they didn't have any gas. It was mentioned that that was one reason they were seeking to take a truck or a car. And so she benefited. She was able to get back to Georgia. When she was arrested, property was found in the apartment where she was, including Mr. Compton's dog. There was evidence that she helped move items from the van into the apartment, according to McCutcheon's, one of her statements. And there was evidence her fingerprint was on the door and her palm print was on the truck bed. And when she was arrested, she blatantly lied about it. She just didn't know anything about it. I didn't go. I stayed in the hotel. I rode back to Georgia in the van. Versus Mangold and Goolsby, who did say something about the crime. Granted, they did not admit that Mangold did not admit that he planned it. Goolsby didn't say Mangold planned it. They didn't tell the cops they still had the gun, and Mangold never mentioned that he went to the house. But according to their plea hearing transcripts, which are in the record, they did say something to law enforcement about the crime. And so, under these facts, there was absolutely competent evidence to support the trial court's findings that that the defendant had not proven they were similarly situated, and with other evidence and did not prove there was a discriminatory effect here. And even though, as Ms. Miller has aptly noted, there could be another view of that evidence here, this court looks at the finding of fact. It is supported by competent evidence and affirms that based upon that finding of fact. In addition, even if the court were to conclude that there was discriminatory effect, of course the defendant had to prove that there was also a discriminatory purpose, and the trial court's finding in that regard was also supported by competent evidence. Again, like with discriminatory effect, this was largely a credibility finding. So even though there may be evidence to point to a different view of the evidence, or even if there's contrary evidence, this court has to accept the finding of fact if it is supported by competent evidence, and there was competent evidence to support it. Both prosecutors gave reasons why they extended pleas to Mangold and Goolsby. Their considerations there were discussed in the brief. And it's undeniable that the thread that ran through Moore and Welsh's testimony about why they didn't offer defendant a plea is that they wanted more from her, and that they never believed that she was telling the truth about her involvement in what she knew. They found her absolutely incredible. This was something they thought prior to the time that Miles and Johnson pled guilty, and even after the letter, the January 2011 letter from Mr. Stewart. And both testified, gave testimony indicating that neither thought that actual pro-offer was much of a pro-offer. He says at the end of it, my client had very little, if anything, something to that effect, to do with the crime here. And with regards to communications between Mr. Moore and Mr. Stewart, yes, Mr. Moore testified that that they were operating under the belief that Ms. Marion would not plead guilty. That was his testimony. And Ms. Welsh and Mr. Stewart and Mr. Decker's testimony was that they were working hard. Excuse me, I'm sorry, I misspoke. Mr. Moore said he was operating under the belief, based upon conversations and interactions with Mr. Stewart, that she wouldn't plead guilty to anything, and that is not what Ms. Welch, Mr. Decker, and Mr. Stewart all testified that they were working for a plea. And again, the finder of fact here is welcome to believe all any or none. So just if there's indication here, as Ms. Miller says, that the finder of fact didn't believe this portion of Mr. Moore's testimony, it didn't mean that he was foreclosed from believing other portions where he gave legitimate, non-pretextual reasons for not offering Ms. Marion a plea. And as to that particular testimony in his part, I think it's worth pointing out that Mr. Stewart testified, his testimony indicated when he was asked about whether there was a response to that letter, and this is on pages 313 to 14 of the MAR transcript, he said no, there was no response to it, and probing why, he said this was characteristic of dealing with Mr. Moore. He wasn't just, the implication, although he didn't come out and say it, was he wasn't just talking about this case. So he was saying this was characteristic of his dealings with Mr. Moore over a period of time that went beyond this case, and that his relationship with Mr. Moore was complicated. So the communication between those two was not optimal, according to defendant's own attorney's testimony. And one of the big reasons they didn't believe her is because her statement was just completely implausible. Some parts of it were. Again, there was discussions in front of her that they were about to hit a lick. There were these guns that were difficult to conceal, and she claimed she knew absolutely nothing prior to the murder that there was going to be an armed robbery here. That's implausible given the evidence. And Ms. Welch's testimony saying that it wasn't clear to her whether the defendant ever went to the house, she gave reasons for why she believed that, and one of them was the statement of Mr. Walthrop about seeing two black men and one black woman. She never, she questioned whether that was defendant or Jada, and also I think what is more important and what she testified to was that there was a massive amount of property taken away from this particular armed robbery and murder. If you look on page 9 and 10 of the Record on Appeal, these are addendums to the armed robbery indictments. It lists the evidence that was taken away, and Ms. Welch said, she said the amount of evidence taken away led her to believe it would take more people to get that out of the house. And with regards to defendant's claim that she was ignorant of what was going on because she was high, Ms. Welch testified that she viewed hours of casino surveillance photos, and in none of those did Ms. Moore appear to struggle in walking, something along those lines. I also think it's important to point out with regards to Welch and Moore's assessment of what defendant was telling them is to look at, there was an email between Welch and Moore on January 13, 2011, and this was prior to the time Mr. Stewart sent the letter that he said was a pro-offer. And in this email, they're having a discussion about the level of culpability of Goolsby, what they can charge him with. And in that particular email exchange, Ms. Moore indicates something about going after Mangold first, and then getting Marion and Goolsby to cooperate and testify, and talks about giving Marion and Goolsby better deals. So at least at some point they contemplated a deal. And then after that, they received that letter, more of the same, more of not believing that the defendant was telling them everything. And then leading up to defendant's trial, Welch said that her understanding of defendant's involvement when she studied the felony murder law, when she studied defendant's involvement, evolved. That was her testimony. And she said at first, consistent somewhat with that email, that she felt sorry for defendant, and her mind changed as she studied the evidence and in light of the felony murder law. There was testimony from defendant's attorney, Mr. Stewart, about the racial attitudes in the area. There was not any testimony specific to the prosecutors. That was about the community. Mr. Decker at first testified that he testified he didn't think the defendant would get a plea because she was a black woman involved in killing a white man. And as he goes on, he's asked, why did you expect there to be a trial? He said because, and he referenced the DA's race, not necessarily, he at that point referenced the DA's race, more of a political reason for why there wasn't going to be a trial rather than based on race. And again, defendant has couched this evidence, the evidence of the MAR hearing, in a different light, in a light more favorable that would be contrary to the findings of fact of the trial court. However, given the standard of review being for clear error and whether competent evidence supports the trial court's factual finding, those findings should be upheld on appeal because competent evidence did support them. And defendant points to, I wanted to just address one more thing. Defendant points to in her brief indicating regarding the community attitude, the attitude of the family, and that one thing Ms. Welch testified that she thought about during the trial was that every time she turned around in the courtroom and had to look at Mr. Wiggins, the father of one of the victims, the former sheriff, and he looked devastated, that had an effect on her. Defendant seems to imply that somehow shows racial motivation. This concern for the family. Of course, the family can be involved. The DAs, it's the law that the family gets information from the DAs about a crime. Family victims are entitled to that as a right and a courtesy. But contrary to that, is that email. I wanted to point that out, is that email exchange between the family member of Mr. Wiggins, that happened to be his sister, Mr. Moore, and Ms. Welch. Ms. Wiggins emailed immediately prior to trial, sent an email to Mr. Moore in which she referred to the defendants here, the African American defendants, with a racial slur. In response, Mr. Moore said, "Don't ever use that term again around me. I know there was no reason for any of these people to kill your brother. If you can't control yourself to keep from speaking like that, I need someone from your family who can." And Ms. Welch was copied on that, so she sent an email to Mr. Moore and said she couldn't believe that Ms. Wiggins had said that, or that she would even think that. And she commended him on his response, saying that it was very good, and that way of thinking made her uncomfortable. In this particular case, Your Honor, defendant did not, as the trial court's finding that there was no discriminatory effect or discriminatory intent was supported by competent evidence, and defendant did not prove for equal protection selective prosecution claim. If there are no more questions, the state will ask that you affirm the trial court's MAR order.
All right, thank you. Any rebuttal?
First, I'd like to address the state's contention that Ms. Marion was not similarly situated to the two white co-defendants in this case. Similarly situated in no way means identical, and if we look to our controlling equal protection case law, that is exactly what is held in the context of jury selection and when they examine a black juror that the state has chosen to preemptorily strike, and then a non-black juror. If we look to both Flowers v. Mississippi as well as Miller L. v. Dretke, notably footnote 6, it does not require that they be identical. If they were required to be identical, it would render the Equal Protection Clause meaningless. And so here, it's that they are essentially considering roughly the same offense, roughly the same level of involvement, under roughly the same circumstances. And by all accounts, Ms. Marion was roughly situated the same as Mr. Goolsby. She remained at the van. Even if we take the evidence in the light most favorable to the state, and as the state has argued, that leaves Ms. Marion as knowing or having seen guns there and recognizing that a robbery was about to take place, and then choosing to remain at the van. That puts her in no worse of a position than Mr. Goolsby, and yet she was still not offered a plea.
What about the state's argument that your client went back to Georgia and there's evidence that she had stolen property with her then, which sort of creates this longer connection to the crime, having the property later?
I think there's a reasonable distinction between Goolsby and Ms. Marion in that Goolsby was tied to Mangold, and they fled knowing where they were in Swain County. They had a friend's home to run off to. Again, though, doing nothing to render any sort of aid for the victims, and Ms. Marion being in the circumstance where she was dependent on the people she was with to get back home. She had no money, no food, no way to provide for herself. And so she took that ride back to Georgia, and there was no evidence, though, that she assisted with moving that property. She was at Jada's apartment where it was located.
I'd like to ask another question related to the state's argument that that your client, I'm sorry, the thought is losing me. That your client's counsel sent, Mr. Stewart sent this letter in January, which caused the prosecutors to take a different turn. That when that letter came, they had been saying, let's see if we can get Marion Goolsby to testify, and they received that letter, which your friend for the state has argued, said something like it's the same as it was before, absolutely denies doing anything, and that this was followed by the course of the prosecutors not offering anything. I don't want to understate the incredible tension that's on any criminal defense lawyer they're trying to do for their client. But, you know, if the defense lawyer sends a letter that offends a prosecutor, that makes a prosecutor think this client is not going to budge, is that within a prosecutor's legitimate discretion?
I think that given, while it could be, I think in looking at the total record evidence in this case, we also have the state claiming that Ms. Marion was essential, and yet despite counsel saying that she was always available for interviews, they did not take any effort to interview her while they did with Goolsby, while Goolsby had counsel. And to the extent that there was radio silence after Mr. Stewart had responded with that proffer. There was no, this can't possibly be all she knows. And it's just not credible that alone, the state then decided at that point she wasn't going to be offered a plea, because it has to be compared to all of the pretextual reasons that have been given this case, which were discredited and contradicted by the record.
You would agree, though, that the findings of facts that the court made are supported by some evidence within the record, wouldn't you? Or are you going to rely on the fact that you believe that the judge couldn't have possibly found that there was not actual intentional discrimination?
As I answered Judge Dietz, I believe that there was the one piece of evidence that could have supported Mr. Moore's contention that Ms. Marion was not going to accept a plea. But as to there being no discriminatory intent and no discriminatory effect, the relevant factual findings were not made in this case. These global findings are not sufficient to support the court's order and the conclusions of law that were made, and to find that there was no equal protection violation. And so,
Can I ask you one last procedural question? So your petition for writ of certiorari tried to address essentially two issues. One is what we've focused on here in this argument, the order, the ruling on the motion for appropriate relief. Then you also had the discovery ruling. And so your friend for the state pointed out that the language of our order issuing a writ of certiorari focuses on the order denying the motion for appropriate relief. In your view, can we reach the discovery question, which was entered in a separate order?
Yes.
On this writ of certiorari?
Yes, Judge. If we look to State v. Martin, for example, that was a case that I had cited as to why, in my reply brief, as to why the court could reach it. These are completely intertwined, the post-conviction discovery that is necessary to file all of the necessary claims through one motion for appropriate relief. It absolutely is within the court's authority to be addressing the post-conviction discovery issue as well.
Yeah, I saw that, but I guess the concern I have is that, so that was not this panel that made that ruling. And my concern is the wording of the order by choosing, knowing that you'd asked for a review of those two orders and choosing to say, we'll issue a writ of certiorari only for the purpose of reviewing the order on the motion for appropriate relief. I just wondered why that was the chosen language by the panel, and if that was because the intent was to issue a writ of certiorari only for this review and not for your second issue identified in the petition. You following me?
Sure, and I can understand why the court would have that concern, and unfortunately I can't speak to the panel's intent, but what I can point to is that the writ of certiorari that was issued in Mr. Martin's case in State v. Martin was identical in that it was as to the order denying the MAR, and then the court remanded for both an evidentiary hearing on post-conviction discovery matters as well.
Thank you.
I see that I'm over my time. I would just, again, remind the court that even if we went with the clearly erroneous standard that the state has advocated for, if not this case, then what case could there possibly be? There has never been, in our equal protection case law, a situation where a prosecutor has come forward and said, you're right, race was a factor here for me. And if that's what's required, then the equal protection clause is meaningless. These facts are exceptional, and Ms. Marion warrants relief. We ask the court to reverse the trial court's order denying the MAR and to order a new trial. Thank you.
All right. Thank you, counsel. We'll adjourn.
All rise. This session of North Carolina Court of Appeals is adjourned.